that if anyone says that jurisprudence is the mother of all subject is very just remarkable word. Jurisprudence may be the mother of the law, it is correct, and there is no doubt in this sentence, you know very well. But if anyone says that jurisprudence is the mother of all subject, then definitely it becomes very important thing. And you know that there are few jurists who said that jurisprudence is the mother of all subject. So you know that it means that all subject is coming out of the jurisprudence. So just jurisprudence is very important subject. Few jurists also say it that it is the eye of law. You know that what is the importance of eye in anyone's life. So it is, if it is the eye of law, definitely it becomes very important to protect the eye, and similarly it is very important to protect the jurisprudence or to understand the jurisprudence. So few jurists has said that it is the science of law, it is the philosophy of law, it is the just you can say lawyer's extra version. So many definition was over there, but we discussed the few definition of the jurisprudence in my first lecture, though that is available on the YouTube. You can again see that lecture. So I only discuss three definition perhaps so far as I am reminding. I discussed the definition of Julius Stone, I discussed the definition of Alpian, and some Hindu just aspect of jurisprudence, and just later we ended the definition of the jurisprudence. So just let us again remind and let us again think that the study of jurisprudence is more than just memorizing rules. So if you are studying just jurisprudence, you are not just only remembering the sections, but there are so many other things which are over there in jurisprudence. So jurisprudence is more than the memorizing rules or sections or articles. Just in my first year when I was the student of law, LLB, I do my BCom, thereafter I joined LLB. Then I used to memorize the articles as well as the sections, and I used to think that it is very fruitful thing to memorizing those things, because if I will memorizing, then definitely anyone will ask me that what is this section, what is this article, definitely I will tell him and I will know the law. But gradually I come to know that that policy did not help me at all and helped me much, though there was some benefit of the memorizing itself. We have seen the movie, you know, that just Three Idiots, and we can link that what is the benefit of memorization or memorizing, or what is the loss. And so just I in my beginning I used to think that memorizing is just good thing. So the study of jurisprudence is more than just memorizing rules or sections. You are not only remembering or memorizing the rules or sections in jurisprudence, it is the exploration of the knowledge of law. So only memorizing the rules or the section or articles, you cannot understand the law. If you are thinking that your memory is very sharp, one day I was teaching in my class, and one fact was told wrongly to the students in my class, and the students asked me, sir, this fact is just wrong. and this fact is this. So I answered that memorizing anything is not very important thing, but the conceptual clarity is the much important thing, because your concept are clear, you understand anything conceptually, then definitely it becomes very important aspect of the study or the teaching, that your concept is clear and you can just teach the students by the help of your conceptual clarity. So, and by the help of that you can have the knowledge of anything or knowledge of the law. So similarly, if we are memorizing sections, it is not much fruitful, but jurisprudence is an exploration of the knowledge of law. So just we explore the knowledge of law by the help of the jurisprudence. So that's why Julius Stone famously said or described it as a lawyer's extraversion. You know that who is the good lawyer, and who can be a good lawyer? So good lawyer not only know the law, but also he know the history, the geography, the philosophy, the theology, the religion, the economics, and other allied subject which is connected with the law. You cannot understand the law without understanding the sociology. You cannot understand the law without understanding the history, because up to some extent the historical aspect, social aspect is over there in law. So Julius Stone famously described it as a lawyer's extraversion. So lawyer not only talk about the law or just keep the aspect of the law in the courts, but he take inspiration from the history, from the sociology, from economics, and he collect all facts by his research and present those facts in front of the judge, and he expand the law. He just help in the just making of new laws, or you can say the judicial precedents. So only by memorizing the law we cannot understand the law, and it is the lawyer's extraversion as per the Julius Stone. It means that not only truly understand the law, but one must look towards other fields like sociology, philosophy, economics, history, geography, etc. This is also the subject matter of the law. So Julius Stone becomes important one to study, and it serves as the theoretical foundation of legal system and provides clarity on fundamental concepts like justice, rights, and duties. So just you know that jurisprudence give the theoretical foundation to the legal concept. You know that the theoretical foundation of the legal system cannot be understood by only understanding the sections, by only understanding the articles, by only understanding the rules, principles. It needs just something more, and that is the jurisprudential aspect, and it gives us a theoretical foundation to understand the legal system as well as the law. Though the principles comes out of the law, principle is the different thing, rule is the different thing, and both may be the law. So as the theoretical foundation of the legal system, it provides clarity on the fundamental concepts like justice, rights, and duties. You know that fundamental concept of law. Definitely, justice is the fundamental concept, right is the fundamental concept, and the duties is also the fundamental concept of the law. So, just let me tell you that if we don't understand the theory, we cannot understand the practical much. You know very well that without understanding the theory, we hope that we can understand the practical. Definitely, it is the illusion. We cannot understand the practical if we don't know the theoretical aspect. So, theory is also the similar important than the as the practical is. And if you don't understand the theory, you cannot much understand the practical aspect of any particular subject, whether law or any other thing, or any other subject. So the just conceptual clarity or the theoretical clarity is the primary thing, and the practical aspect is the secondary thing. But what happens in the material world, we see that we give importance to the practical. We see that if we know the practical, it is enough, and there is no need of the theoretical knowledge. But theoretical knowledge in itself have the similar importance. So it serves as the theoretical foundation of the legal system and provides clarity on the fundamental concept like justice, rights and duties. So if we are studying law and we don't understand justice, we don't understand rights, we don't understand duties, we don't understand possession, ownership, what we know about the law? We know nothing. Just we can say that I am the practical lawyer, I am the practicing lawyer. What is the need to understand justice? What is the need to understand right? I go to the court, I give the application, I just talk to the clerk, and I get my work done, and it is running in the legal field. I am concerned only with it that my work is done and I don't care anything else. But it is not the correct approach. The theoretical knowledge is also important as the practical knowledge is. Both have the same importance, but rather we can say that the theoretical knowledge is much important than the practical knowledge, because if you are not having theoretical knowledge, or your theoretical foundation is not solid, you cannot run far away, you cannot go away, you will limitify yourself, you cannot go beyond imagination, or you cannot run afar. So the nature of the jurisprudence is multifaceted, encompassing philosophical, analytical, historical, social, as well as political aspect. So nature of the jurisprudence, I also have taken the class on the nature of the jurisprudence, and that is also available on YouTube. So nature of the jurisprudence, I also told you, is the multifaceted, and it encompassing philosophical aspect. Jurisprudence nature is the philosophical nature, analytical nature, historical nature, conceptual nature, theoretical nature, abstract nature. I told you earlier these all things. So philosophical, analytical nature, historical nature, and these are all aspect is talked by the jurisprudence. Its scope is vast, very vast. You know that jurisprudence not only talks about law, but it also talks about the other subject which is other than the law. It talks about history, it talks about philosophy, it talks about religion, it talks about sociology, it talks about geography. You know that historical school of law, what he talks about the geographical, he talks about the language, he talks about the customs. So many things are also the part of the jurisprudence, and its scope is vast, ranging from the study of the fundamental principles applicable across all systems known as general jurisprudence to the study of the specific legal system referred at particular jurisprudence. You know very well. So its scope is very vast. You cannot limitify the scope of jurisprudence to the only law, but other subjects are also the subject matter of the jurisprudence: history, geography, political science, theology. So these are all things. And let me tell you that its scope ranging from study of the fundamental principle applicable across all system known as general jurisprudence to the study of the specific legal systems referred as to the particular jurisprudence. So you know that there are two types of the jurisprudence: general jurisprudence and particular jurisprudence. If I am not wrong, it was classified by just Austin, and he said that general jurisprudence talks about all legal systems common principle, and specific legal system talks about the particular jurisprudence, or just you can say that it talks about the Indian legal system or American legal system or Japanese legal system. So if we are talking about any particular legal system or specific legal system, then it becomes the particular jurisprudence. When we talks about common laws in all legal systems, then it becomes the general jurisprudence. So general jurisprudence are common in all legal system, whether American legal system, Indian legal system, or you can say French legal system, British legal system. Those principles which are common, which are same in all legal system, called the general jurisprudence, and the system which is specific in any particular legal system, that called the particular jurisprudence. So jurisprudence is two types: general jurisprudence, particular jurisprudence. And आई होप और किसी दूसरे देश में नहीं होते हैं, तो वो पर्टिकुलर jurisprudence में आ जाएंगे. तो let me tell you that general jurisprudence is the study of the specific legal system, and general jurisprudence is the study of all common systems, while the specific legal system is studied in the particular jurisprudence. So now you know that tariff bar which is running on these days. So it is very necessary to understand the importance of this general jurisprudence and particular jurisprudence with reference to American war, tariff war, because you know very well that if my country having any specific law for Indian people, that law will be applied in my country, and that law, this law will not be the same in America. American law on this point may be the different, and it will come in the purview of the particular jurisprudence, because in a specific legal system there may be some different rules as per the Austin, you know. In general jurisprudence, all common legal concept, theory, principle would be covered by the general jurisprudence, and these legal system will be common in all legal systems. So just let me tell you that America is making its specific rules for the world. It is imposing tariff, and this is very unique incident of the world which has never seen earlier. You know that in the world history, very few, you cannot find the similar example of imposing tariff on the countries by a powerful country. This is very unique and rare incident, and perhaps first time incident in the world history. And we have witnessed the might and right law, the monarchy we have witnessed, the anarchy, we have witnessed the dictatorship. But tariff as a arm has never been used in the world history. It is firstly used by the America, you know very well. So you know that according to the particular jurisprudence, America is justifying it that I am powerful, I can impose the tariff on you because my country is having the specific legal system, and I will impose tariff on the other country, though the sovereignty of the other country is hampered by this approach of the American tariff policy. So definitely you know very well this particular jurisprudence in respect of the America or in context of the America is not the just meritorious thing or the beneficial thing or utility-full thing. Because if the powerful country will use the tariff or any other things as a weapon, definitely it is the misuse of the power. It is not the rule of law. It is the violation of the just international laws. So this approach of the Estonian view, which divide jurisprudence as general jurisprudence and particular jurisprudence, now should be understood deeply. And I think that either there should be the general jurisprudence in whole of the world, meaning thereby the world should be guided by the common legal principles, and in the all world there should be the common legal principles in all world. Or we can rely on the natural law theory or natural law school, which just principle or which rules or which ingredient is unique one, which is having the morality, which is having the values. You know that the carbon tax, you can see the the institution, or I'm talking about the world institution, which is just diminishing on, which is collapsed these days, whether that is the IMF, whether that is the UNO, United Nations Organization, whether that is WTO, World Trade Organization, whether that is the World Health Organization. These are all big institutions of the world has been hampered, has been disturbed, has been collapsed. And you know that until and unless we make the law same for the whole world, we will complain that America is not respecting the international law or natural law or the humanitarian law or the moral law. There is no morality. If I am watching my benefit to occupy the Greenland, I am again and again just creating such situation which may be the initiation of the Third World War. So definitely all legal system should rely on the general jurisprudence, and they should throw out the particular jurisprudence, meaning thereby the whole world should have the same law or the similar law. My country should not have the different law, America should not have the different law. But I think that it is very necessary, otherwise the world order will be collapsed, the morality in the world will be collapsed. America will impose the tariff. Yesterday China will be powerful, then China will impose the tariff on the world. Next day the France will be powerful and France will just impose the tariff on the whole of the world. So general laws or the common laws for all of the world is very necessary and the need of the time. So I hope that which we study should be in the whole world, or the same laws should be for the whole countries, all of the countries. The law should not be different for the different countries. So just general jurisprudence should be the subject matter of laws, and the special laws or the historical view of the law, that law may or should be different for its own reason, own language, is not beneficial for the world order, is not beneficial for the humanity, because the powerful countries or whosoever will be powerful will just misuse the law. If we will think that if the my law for my country should be different, law of the other country may be different. So this approach may be very dangerous for the long run. Now let us understand historically. Understanding of law has been shaped by the major school of thoughts, and you know that first big school is the natural law school. And you know that one thing is this, that natural law school and law of the nature. I want to ask you, is there any difference between, देखिए हम जो आगे बात कर रहे हैं, let us understand that natural law school is the oldest branch of legal theory, viewing law as a higher law. So it says, natural law school says that law is the higher law. You know, one is the high law, second is the higher law, more than high. So it is discovered through the human reason. You are just discovering it, finding it by your reason. What you are finding? You are finding the law or the higher law by your reason, by your logic, by your thought, rather than created by state. It is not created by the state. You know that creation is the artificial thing. If you create something, it means that you made. But if something is already exist and you discovered, then definitely the good thing, because that was earlier having the existence, you only discovered that. So human reason, you know that higher law discovered through human reason. So there is law, but we are not able to see that is the natural law. But when we discovered, we rely on it. You know that what we discovered by natural law, we discovered odi alteram partem. We discovered just no one can be judge or in his own case. We discovered that here the other party before the judgment, just we discovered that procedural fairness. We discovered that the substantive fairness. So these are the principles. These are the principle of the natural law, and it is based on the human reason, and this law is discovered by human reason. This is already existed, but state made law is created, that is not already existed. It means that the state made law or the positive law is the creation of the man. I am powerful, I create a law, I am the father of that law. Hitler is the father of the fascist law, because he was powerful, that he make the law. And analytical school says that law is the command of the sovereign backed by sanctions. Similarly is done by the America right now. You know that the tariff war or the bad eye on the Greenland, and so many countries has been destroyed by America earlier on the name of the democracy. And you know that by keeping the by giving a dog good bad name and kill him. This was the policy of the America earlier, and again on this policy in the Greenland, this policy in the tariff war. So we should rely on the journal jurisprudence. We should just make such types of the world institution, which impose the same law on the whole world. Otherwise, America will misuse on the name of the specific law or in the name of the specific jurisprudence or just particular jurisprudence. So, just human law is created by the state, and the person who is powerful, he makes the law. So, it posits that law is universal, eternal, and must be rooted in morality. So, what is the reality? Law is universal, eternal, and must be rooted in morality. You know that law, according to the natural law, it must be the universal, meaning thereby that at every place, at every time, the law should be the same. For every person, law should be the same. It should be the eternal, because we don't create it. It is discovered by us. That's why it was eternal. It was earlier existed. We only discovered it. And it must be rooted in morality. So natural law is just grounded or rooted or just take birth by the morality, ethics, values, honesty. And you know that in the tariff law there is no morality. If you won't accept my whim, or you won't just you can say won't accept my order or will not do work according to my will, then definitely I will punish you by the tariff or by attacking you. So it is not rooted in morality. According to this school, man-made law is not valid if it contradicts the law of nature. So you know that law of nature, if contradicted by man-made law, then definitely that man-made law is a void law, unconstitutional law, illegal law, or just you can say not a law at all if it is not in conformity with the natural law. So just you can say that man-made law is only good when it confirms the higher law or the natural law. And this second one is the analytical school. I earlier discussed in my class about this school, and you know that law is the command of the sovereign backed by sanction. It is the three sentences or four words we can summarize is sovereign, sanction, command, duty. This is the philosophy of this school. 9th century, it was this school emerging in 19th century. This school focuses on law as it is rather than how it ought to be. And you know that it talks about law is this, and it ignores what should be the law. John Austin, primary figure, defined as the command of the sovereign backed by sanction. You know very well that what is said by the John Austin. He said law is the order or command of the powerful or politically superior person, and if you won't follow it, you will be punished by that powerful person, because he is having power, he is having gun, he is having muscle power, man power, money power, political power. That's why he is powerful, and you will have to follow him, otherwise you will be sanctioned or you will be punished. So this approach strictly separates law from morality. So it don't talk about morality. It don't say that you are to save that person who are hungry, who are dying from hunger, there is no need to save that person. This is not your responsibility to save that person, the person who is sinking. You know, there is no duty of you to save him. So I don't talk about morality, ethics, values, honesty, etc. If you are powerful, you will just slap me and take my car. There is no concept of the right at all. I am powerful and give me this car to me because I am powerful and I am sovereign. So I can snatch your car, snatch your chain, snatch your mobile. So this school strictly separates law from morality, treating it as a scientific subject of inquiry. So this analytical school treats law as a scientific subject of inquiry. It says law is the science. You know that what is the view of the Holland? Law is the jurisprudence is the formal science of positive law. Similarly, Austin said that law is the just science of civil law. And similarly, Austin said it is the philosophy of law, although his meaning of the philosophy is somewhat scientific one, not the ethical or morality based just subject, but his meaning of the philosophy was that one which was near to the science, not from the morality or ethics or value or just honesty. So we discussed these two schools. Thereafter we came on the realist school, though the lecture of the realist school has been taken by me earlier too, but let me again take this lecture and summarize this realist school. And legal realism, this lecture was taken by me yesterday, and today is 31 January 2026. Again I am summarizing it, that legal realism represent a shift towards seeing law as a practical empirical reality. It prioritizes the law in action over the law in books, suggesting that the written statutes are often smoke screens for the true motives behind judicial decisions. So just that realist school or the legal realism represents a shift towards seeing law a practical empirical reality. As I told you earlier, that it is a shift or it is a movement, and this school represent a shift towards seeing law as a practical empirical reality. So it says that what is in practical meaning of law. If we go to the code, we see that the person who is just hooligan, who is the murderer, is left or is given the relief. The person who is victim is not given relief. So what is the practical of the law? Is law beneficial for that person who was the victim or not? So it sees the empirical reality, or it sees the experienced reality. In experience we find that person who was guilty is saved by the power of the state or by the personal biases of the judges or subjective aspect of the judges. So this is the practical thing. This is the law did not help him, help that person who was the victim one. So it prioritizes the law in action over the law in book. So it says that what is the law in action? Don't talk about the law in book. We should not see the law in the books, because law in the books, maybe the person who murders will be punished, but law in action is this, that the person who murders is saved, and the person who is the victim of this is victimized again by the process of the law, lengthy process, long just running of the cases. So law in book, law in action, these are two things suggesting that the written statute are often smoke screens. So they don't rely on the written statutes or written law or sections. What will do the section? It cannot punish anyone. Ultimately, the order is to be written or is to be pronounced by the judge. And if you just manipulate the judge, if you just handle the judge, if you manage the judge by any way, by biasness, by bravery, by ideology, by relative, then you will win the case. So realists believe law is actually a prediction of what the court will do in the specific case. So you know that this is movement is in America, and you know that who is supreme in America. You know very well the judiciary is supreme in America. Not legislature supremacy is there in America, nor just you know that executive supremacy in America, nor just constitutional supremacy in America. Who is supreme in America? The judiciary is supreme. So if judges are biased, if judges are having the nature of taking bribe, if judges are just prejudice, if judges are having certain types of the ideology which is reflected in his judgment, so definitely this is hampering the justice, this is hampering the higher law. So definitely realist belief law is actually a prediction of what a court will do in a specific case. So if any particular case come in the court, then if the judge give him relief, so then definitely it is the law that I am benefited, though I was murderer. So they just say that law is that which is said by the judges, and there are so many factors behind the judgment. Background may be, personality may be, bribe may be, relationship may be, biasness may be, ideology may be. There are so many factors behind the judgment that also play a crucial role, and law just only a spectator at that time when the judgment is delivered by the judge. So just this realist school talk like this, though this has been discussed by me earlier. Now within the realist movement, thinker identify two types of the skepticism. Yesterday I also talked to you about the skepticism. One is the rule skepticism, and second is the fact skepticism. So this idea that the legal rules are inherently vague and allow judges to select rules that fit a desired outcome. So you know that I told you earlier also that the law which is made, the section which is made, the regulation which is made are inherently vague. They are not clear, they are not specific, they are not identifiable, they are vague, they are just foggy. So sections or laws, regulation, rules are inherently vague and allow judges to select rules that fit a desired outcome. So what the judges do? They select those sections or those rules that fit the desired judgment, and also the precedents also help them in this work to give the desired judgment. So thus this is the policy of the judges to select the rule that fit the desired outcome. And next is the fact skepticism that is popularized by the Jerome Frank. You know that what was it? This view argues that the facts of the case are never truly objective, because they rely on the fallible witnesses and the biased juries and the procedure, complex procedure of the court, which just shift the judgment's nature. So this is the fact skepticism, and it says that fact of the case are always different one, and they are not same. So one judgment cannot come by every fact, by every case. Every case is different because the case are never truly objective, because they rely on the fallible witness. The memory of the witness is short. He want to say something else, and he utters the words something else due to the persuasion of the lawyer, due to the pressure of the court, due to the biasness of the judges or subjective interpretation of the judge, and due to the language written, got written by the lawyer, or by giving some you can say bribe to the clerk who is writing the judgment. He shifts some words in favor of anyone, other party or opposite party. So just the case are never truly objective. Case are different and different in every case because they rely on the fallible witnesses and the biased jury. So the juries is always or in most of the cases or in many cases are biased, or they make the subjective interpretation of any particular fact, and the judges just mislead, or you can say just give any different interpretation which is accepted by the judge, which is the skill of the advocate while cross-examining, while representing the case. So this fact skepticism is always over there in every case. That's why we find that in one case there is the different judgment, and in the same other case there may be the different judgment, though the fact of the case may be different. But it is very unfortunate thing for the legal system if law is not certain, if law is not just specific, if law is not identifiable, then definitely it is the how can a common man rely on the law if he is finding the different judgment on the same fact cases. That's why the consistency in the judgment, the precedent rule becomes important. So law should not be changed hurriedly, or the natural law or the higher law should be relied fully, because it is the law which rooted in the morality, ethics, values, honesty, modesty, humanity, kindness, etc. So this human element is famously summarized by the breakfast theory. And can you tell me please, in law, just you want to understand this human element in law, then you can understand that if the judge take the marvelous breakfast or good breakfast, and then he goes to listen the case, or he go to hear the case, his judgment may be in favor of the accused. Otherwise, if he has not taken the good breakfast or marvelous breakfast, or he has not eaten the just good food in the breakfast, then his mood is upset and he may give the judgment against that person who is in front of him. So this breakfast theory talks about the human element in law. If my mood is good, I will welcome you. If my mood is not good, I will not welcome you. So this breakfast theory is the part of the realist theory, which jokingly suggest that the judge's decision might be influenced by something as personal as what they had for breakfast. So, you know very well that judge's decision may be influenced, may be affected, may be changed by this, that he has taken good thing in his breakfast, then his mood is fresh, his mood is good, he will give the judgment in favor of the accused. If he has not taken the good thing in his breakfast and his mood is upset, or he has something disturbed in the morning shift, some incident has been occurred with him and that his mood is not good, definitely its effect will be come on the judgment. This is the human element in law. So just it is something as personal as what they had for breakfast. So if he has taken the good thing in breakfast, then definitely he will give the judgment in favor of the accused. Otherwise his mood is upset, he will not give the judgment in favor of the accused. So Holmes captured this sentiment by stating that the life of the law has not been logic but experience. So Holmes said that life of the law is not logic. So law is not understood by logic, but it can be understood by experience. I was correct, I was not guilty, but judge's mood was upset. Judge's mood was upset and he declared me guilty. He declared me as convict. I did not do the crime, but his mood was not good. That's why he just imposed his bad mood on me, and he said that you are a culprit or you are the convicted. So this is the experience of me, that in spite of being innocent, I was punished due to the judge mood, due to the judge's biasness, due to the judge's personality, or that he is a person who takes the bravery. So the judgment is influenced by these facts. So in conclusion, the jurisprudence is the indispensable for legal practitioner and students. So what we say about the jurisprudence, generally lawyers, advocates and the law students say about the jurisprudence, it is somewhat philosophical subject, abstract subject, just you can say theoretical subject. So why should we understood this don't come in the court, there is no section in it, so we just there is no need to study it. But it is the parameter of law, it is the touchstone of the law, it is the criteria of the law, it is the eye of the law, it is the mother of all subjects or all law. So it bridges the gap between law and society. So law is applied on the society. So if you don't understand the jurisprudence, neither you can understand the law nor you can understand the society. So guiding legislature and judges, so jurisprudence guides the legislatures how to make law, what should be the element of the law, how the law should be, what should be the element in a good law. It should have the universality, morality, it should have the human benefit, it should be ethics, value, it should be higher, it should be compatible with the natural law. So all legislature or judges is guided by this jurisprudence subject, which is very important subject, though all laws are very important subject, and all laws should be understood thoroughly. So to ensure the legal systems remain relevant to the changing societal needs. So you know that if we want just that legal system remain relevant in the changing societal need, then definitely the jurisprudence subject is very important one, is very crucial one. Because without understanding jurisprudence, how many sections you understand, how many sections you memorize, it will be the useless thing or fruitless thing, or just you will not get the benefit of those section in understanding the philosophy, the depth, the need, or the relevancy of the law. So definitely jurisprudence is very important subject. Though all law is very important subject, your one law or one subject in law is weak, definitely your other subject will be the weak in the similar ratio, because the chain is as strong as its weakest link. So if your one subject of law is weak, definitely other subject is bound to be weak. So I hope with this all you best of luck, and I have summarized the definition of the jurisprudence, nature, scope, and the of jurisprudence. Similarly, I summarized natural law, analytical school, and realist school. If you are having any